So thank you for joining us today. Today's workshop is going to be on Shepard citations. We have Lynn Smith here from LexisNexis. She's a training consultant and she has a law degree and master's degree in library studies. She's worked for LexisNexis for over 20 years and she's conducted many trainings for students like this one. So please keep yourself muted during the presentation, but at the end, if you want to unmute yourself, feel free to ask your questions. And you can use the chat in Zoom if you have questions during the presentation. So without further ado, let's let Lynn get started.
Thank you, Julia. I really appreciate this opportunity. And what we're going to be talking about today, or what I'm going to be covering, is Shepards. And Shepards is a critical part of the legal research and writing process. And I will go into details, what exactly is Shepards? Why is Shepards important? I like to say that this is actually my favorite webinar. And the reason is I have a BA in history. I also have, as Julia indicated, a master's in information library studies and a JD. So I like to say I am an information geek. I love all types of information, relevant information, irrelevant information, but more importantly, I love history. And Shepards is basically a history lesson in law to a certain extent, but I'll go into that. So one of the questions I always get is, what is Shepards? Why do we care about Shepards? Well, number one, Shepards is what we like to call a citator. And you're like, okay, Lynn, what's a citator? Basically, what Shepards does, without you realizing it, is that it gives you the complete history of how a legal document has been cited in other legal documents. So when we go to Shepards, it's basically giving you the history of how that particular legal document, whether it's a case, a statute, you can even Shepardize a law review or a law journal, how it has been cited in treatment in other legal documents. Shepards is also a secondary source. It's a great secondary source because once again, I just told you that Shepards is a citator. It gives you the complete history of how that particular legal document has been cited in other documents, legal documents. So that's why it's a good secondary source, because if I want to see all of the cases that cited a particular case from Ohio or from Oregon, I can. But most importantly, it is a validation tool. And that's what I think most of us, when we think about Shepards, we think about Shepards in terms of it being a validation tool. Now, why do we Shepardize? Basically, I always tell people, we've turned Shepards into a verb. Somebody would say, go Shepardize this case, go Shepardize this statute. And basically what they're saying is, go check the validity. Make sure it is still good law. So I always tell people, when you're doing legal research, you found that case, you read it, you're getting really, really excited because you think it's very, very relevant to your particular issue, the topic you're working on. But before you get too excited, you must verify that it is still good law. So basically, you're checking the validity. You're trying to make sure it's still good law. So what is it that we're looking for? Basically, when we go to Shepardize, we're looking for three things, three key things that would make a case bad law. Number one, has it been reversed on appeal by a higher court? So you're looking for that reversal. Has it been reversed? Or has it been overruled in a different case decided by the same court or a higher court? Think about the United States Supreme Court. The United States Supreme Court is the highest court of our land. There's no court higher than the United States Supreme Court. So anytime it looks at one of its own decisions, its own cases, it can only do one thing: overturn, overrule. So when you get to like, our highest court of our land, United States Supreme Court, like I said, the only thing it can do is overturn or overrule itself. Pretty much the same concept on the state level. However, there is a court that is higher than your state's highest court, and that, of course, is the United States Supreme Court. But most state highest court, and the reason I'm saying highest court and not Supreme Court is that's incorrect terminology, because not every state refers to its highest court as the Supreme Court. I always like to use New York. More importantly, if you watch Law and Order, the original Law and Order that they're actually bringing back to television. If you paid attention, Jack McCoy was always going to the Supreme Court. That is because in the state of New York, its highest court is not referred to as the Supreme Court. So it's incorrect legal terminology to say that every state refers to its highest court as the Supreme Court. So the highest court of your state, if it's looking at one of its decisions, yes, it's going to overturn, overrule. But like I said before, of course, there's a court that's higher than the state's highest court. And then don't forget that we have a check and balance when it comes to our government. We have that judicial branch, executive branch, and legislative branch. And they all create laws, but they can also truncate each other. So that legislative branch, in conjunction with the executive branch, and sometimes not in conjunction with the executive branch, because we know that that legislative branch can override a veto. They can create laws that truncate, supersede case law, just like we have that judicial branch that can look at a piece of legislation that was enacted. And what I mean by enacted, meaning it became law, and say, that bill that became law, that became a statute, is unconstitutional. So basically, three things that we're looking for: reversal, overturned, overruled. And like I said, we have a check and balance when it comes to our government. The judicial branch can deem a piece of legislation that became law, a statute, a code, as unconstitutional. That legislative branch can pass a bill that becomes law that truncates, supersedes case law. Now, what I always tell people about the legal world is that in legal research, it's not about old and new. It's about good and bad. Meaning you can have a case from 1788 that is still good law, but a case from 2018 that is bad law. So in our world, it's got nothing to do with old and new. It has to do with good and bad. We only cite to good precedent, good law. We never cite to bad precedent, bad law. As I said before, Shepards is a citator. It is a secondary source. We can use Shepards to find additional cases that stands for the same legal principle or statement. So what I'm going to do now is I am going to stop sharing just for a moment. I'm going to stop sharing this PowerPoint presentation. And then I'm going to go to the product itself. And we're going to Shepardize some cases, just so you can take a look at how Shepards, it's not all just very simple. I wish it was simple. I always tell people, this is where legal research gets complicated. This is where legal research can get a little confusing. And we're going to also Shepardize a statute, because even though most of the time when we talk about Shepards, we think about it in terms of case law, but you can also Shepardize a statute, which I'm going to do. So I'm going to first go get a decision, and I'm going to get that decision by simply typing in a legal citation. And just want to give you a friendly reminder that right now I am typing in proper Blue Book citation. However, it is not necessary to type in proper Blue Book citation. So I've got my 410, which is the volume, space, uppercase U, period, uppercase S, period, space, 113, which is the page. So I'm saying I need volume 410 of the US reports and open it up to page 113. Well, if you're at the beginning of your legal studies career, you may not necessarily be that comfortable using proper Blue Book citation, and that's perfectly okay. So if you notice, I still have my citation, but I took away the spaces, I took away the punctuation, that U and that S are in lowercase. I don't have to type in proper Blue Book citation. The system is very flexible. Now, on your cases, on your decisions, opinions, interchangeable terminology for the exact same thing, you're going to see what I like to call the lucky charm symbols. And I'm going to show you how you can get a nice little description of the lucky charm symbols. But what they're trying to do, here we see this red stop sign that says stop, serious negative treatment. You better Shepardize. You may see a yellow triangle that means some negative treatment. Please keep in mind, regardless of what I like to call the lucky charm symbol, you always have a duty to Shepardize. But those symbols are just trying to give you some type of indication to the treatment, to the analysis that has been applied to that specific case. So yes, red stop sign, you better Shepardize. Yellow triangle, you better Shepardize. Green diamond, which basically means positive treatment, you still Shepardize. That is just a thing that we do in the legal world, regardless of that lucky charm symbol, you always have a duty to Shepardize. Now, what I can simply do is over here on the right side, simply click on this Shepardize this document, but you can also click on the lucky charm symbol. But I'm going to click on this Shepardize this document. And this is going to go and do just that, Shepardize Roe v. Wade. And remember, I told you, number one, Shepards is a citator. It's going to give us the complete history of every single legal document that has cited Roe v. Wade. So over here on the left side, this is going to give me every single jurisdiction that has cited Roe v. Wade, whether it's on the federal level or on the state level. But if I go up to the top and I see other citing sources, this will give me every law review that has cited Roe v. Wade, secondary source, statutes. So basically, number one, it is a citator, trying to give you the complete history of every legal document that has cited Roe v. Wade. I'm going to go back to my citing decisions. So, like I said, if I want to see only those cases from the state of Ohio that cited Roe v. Wade, I can click on Ohio and view all 83. So that's that citator concept. Also, secondary source. This is giving me all of the cases in Ohio. But I'm going to clear that. Well, like I said, the primary, one of the real reasons is that validation tool, trying to make sure that that particular legal document is still good law. Because if it isn't good law, we cannot cite to it. We cannot use it. We only cite to good precedent. So I told you we're looking for that reverse, reversal, overturned, overruled, and then we have 3 branches of government where we have a check and balance. So looking at my analysis, You see overruled in part by. What is critical is the in part. That right there tells me that part of Roe v. Wade, not all of Roe v. Wade, because we know as of today, March 25th, 2022, a woman still has the right to choose. But part of Roe v. Wade is bad law. Now, on your cases, you have head notes. And if you're not familiar with head notes, just be aware that in the legal world, we like head notes for two primary reasons. Number one, head notes allow us to quickly and easily to identify the different legal topics, the different legal issues that are being addressed in that particular case. And trust me, 90% of the time, a case is dealing with more than one legal topic, more than one legal issue. And we also like head notes because they allow us to quickly and easily to get to that particular part of the case where that particular legal topic is being addressed. But what I need for you to understand is that even though most people, when they think about Roe v. Wade, they think about the abortion issue, the woman's right to choose issue, there were other legal topics, other legal issues that were addressed in Roe v. Wade. So I'm going to click on this overruled in part by. And this is going to bring up Planned Parenthood versus Casey. And it's telling me right here, guess what? Overruled in part by. And it's giving me the exact page that is being overruled in part by. It's overruled in part by on page 873. But more importantly, this is the language. This is the language that is overturning, overruling part of Roe v. Wade, not all, but part. So if I click on this, this is essentially going to take me to this information. And if you start to read, you will see basically what's going on is Roe established a trimester framework to govern abortion regulation. Now, if we continue to read, we will see that during the third trimester, when the fetus is viable, prohibitions are permitted, provided that the life or health of the mother is not at stake. Basically, what this did is said, okay, Roe created a trimester framework to regulate abortion. But this court, the Supreme Court in Planned Parenthood versus Casey, basically said that third trimester, we're reworking that. We're going to say the fetus is viable. And basically, this opened up the door for what many states deemed as late-term abortion, third-term abortion. Many states have banned or prohibited late-term, third-term abortion based on this part of Planned Parenthood versus Casey, saying, nope, we don't agree with the trimester framework that came about, that Roe established, and we're basically redoing that trimester framework. So most people don't realize that Roe established, the trimester framework to regulate abortion, but Planned Parenthood versus Casey changed it. And that has opened up the door for late-term abortion being prohibited, banned in many states. But the thing I need for you to understand is that it only overruled part of Roe v. Wade. So you see this overruled in part. Now what I'm going to do is I'm going to go back to my default page, my home page, and I'm going to type in Plessy. So I'm thinking of the case of Plessy v. Ferguson. And as I'm typing Plessy, the system's trying to anticipate my needs. It's trying to figure out what exactly is, let me help you out, Lynn. Here is a case called Plessy v. Ferguson. I'm safely assuming that's what you're looking for, and that is. Now, we all know that Plessy v. Ferguson was the United States Supreme Court that basically established the doctrine of separate but equal, which of course led to Jim Crow laws, which was eventually overruled by Brown versus the Board of Education, the Board of Education of Topeka. So once again, you're going to see this Lucky Charm symbols. And like I said, regardless of what you see, you always have a duty to shepardize. Excuse me, but it's giving you some type of indication of what type of treatment, what type of analysis has been applied to that case. So once again, I can click on my Shepardize this document or the Lucky Charm symbol, and I'm going to go with the Lucky Charm symbol. And like I said, we all know that Plessy v. Ferguson was overruled by Brown versus the Board of Education. So here we see this overruled by. We don't see overruled in part by, we see overruled by, meaning all of Plessy v. Ferguson is bad law. I'm going to click on overruled by, and it gives us, once again, Brown versus the Board of Education. It's telling us it's overruled by on page 494 of volume 347 of the U.S. reports. Once again, here I have this language. This is the language that's overruling. Plessy v. Ferguson is also a hypertext link, which will allow me to go to the actual part of the decision. So if I read, but the key thing is any language in Plessy v. Ferguson is rejected. It's not saying part of Plessy v. Ferguson, it's saying all of Plessy v. Ferguson. So this is where Shepards gets complicated, because sometimes the court will overrule the entire decision, as it did in Plessy v. Ferguson. And sometimes it will only overrule part of a decision. And when you see that in part, you should get a little light bulb that goes off in your head that says, you know what? I've got to go and read that case, read that Planned Parenthood versus Casey to determine which part of Roe v. Wade is bad law. Is it the legal aspect that I'm looking at? Or is it another legal aspect? Meaning the legal aspect that I'm looking at is still good law, and I can cite to it. On your cases, on your decisions, you're going to see what we call the disposition. And the disposition sometimes to read this, overruled. But sometimes it may read overruled in part and affirmed in part. Basically, what the court is saying is that it agrees with one legal aspect, but it disagrees with another legal aspect. And that is what's been reflected in Shepards. So when you see that overruled in part, it is your job, it is your responsibility to go and read how that particular case was overturned or reversed. Like I said, in your aspect of the case may still be good law, which is, yes, you can cite to it, or it may be bad law, but that is your duty to go read and make that determination. What I'm going to do is go back to my default page, my home page. And this time I'm going to go get a case, and I'm going to go get the case of Dred Scott. And because we refer to Dred Scott as just that, the Dred Scott case, which isn't its proper name, the proper name is actually Scott versus Sanford. I know that, but most of us do not know that because we just like to call it the Dred Scott case. So what I'm going to use at this time is get doc assistance. I like to say, I really wish we would call it get a legal doc assistance. And I'm going to do cases by party name. And I'm going to type in my Dred Scott. Select the jurisdiction, United States Supreme Court. Now, for those of you that are unfamiliar with the Dred Scott case, Dred Scott was a slave. His master took him from a slave state to a free state, back to a slave state. And Dred Scott sued for his freedom, where he sued and said he was free. And the Supreme Court said, sorry, Dred Scott, you're not free. You're still a slave. But the more significant legal doctrine that came out of Dred Scott was anybody of African descent, whether they were free or slave, could never be a US citizen. And therefore, they're not entitled to any of the rights and privileges that we know are stated in the US Constitution. So Dred Scott, basically, Supreme Court, if you're of African descent, don't care whether you're free or a slave, you can never be a US citizen. Well, we had something that happened called the Civil War. And from the Civil War, we get the 13th Amendment. And we all know that the 13th Amendment did what? It abolished slavery in the United States. But there's this problem. The problem is we've got this Dred Scott decision where the Supreme Court said anybody of African descent, whether they are free or a slave, couldn't be US citizens. So now you've got a whole population of former slaves that have been freed, but we got a Supreme Court decision that says they're not US citizens. And of course, this brings us to what? The 14th Amendment, which basically did what? It gave citizenship, not just to the newly freed slaves, but anybody of African descent. So this is where we get into that check and balance. So now what I'm going to do is I can click on the Lucky Charm symbol. And this is going to Shepardize that Scott versus Sanford, better known pretty much most of the time as the Dred Scott case. And we see superseded by statute, but really superseded by constitutional amendment. Basically, that legislative branch working with all of the states to ratify our US Constitution. So if we go and we, look at these cases, basically, they're going to tell us, that 14th Amendment, we've got, the 14th Amendment, which basically gave, legal citizenship to, slaves, people of African descent, and others, So this is showing you that concept of the check and balance aspect of our government. So far, I've been Shepardizing cases. And like I said, most of the time, when we think about Shepards, we think about it in terms of cases. But you can Shepardize a statute, and that's what I'm going to do. I'm going to type in a legal citation for a statute. And once again, it does not matter which abbreviation you use. This is going to be a federal statute. I can use my USC, which is United States Code, which is the official publication because it's published by the government. United States Code Annotated, USCA, or United States Code Service, space 7. So I want Title I, Federal Statute, USC, USCA, USCS, Section 7. But once again, not necessary to use proper Blue Book citation. Now, some of you, I have a feeling that you're a little young. So you do not remember the Clinton administration. You probably were born, but it's not in your memory like it is in my memory. So basically, during the Clinton administration, Congress passed a bill that became law that was called the Defense of Marriage Act. Basically, what the Defense of Marriage Act did is that it tried to define marriage on the federal level, because it's a federal statute. It tried to define marriage on on the federal level as between a man and a woman. So during the Clinton administration, we had the Defense of Marriage Act, which was a piece of legislation that was enacted into law. And within our federal statutes, on the federal level, what they tried to do is define marriage as between a man and a woman. Well, Supreme Court came back and said, no, can't do that. So here, Shepardize's document, this particular statute, this particular law was deemed unconstitutional. So if I click on this unconstitutional by, this is that piece of legislation, this case where the Supreme Court said, can't do that. Marriage, going back to our, equal protection of the law, due process. So just kind of FYI, everyone. So here's that Defense of Marriage Act, unconstitutional. I'm going to use my head notes to go straight to the courts. So just so you know, due process, equal protection of the law, keep in mind that it is found 2 places in our US Constitution. It is found in the 5th Amendment, and it is also found in the 4th Amendment. And people always say, well, why is it found twice? Well, the 5th Amendment only applies to federal. 14th Amendment applies to state. You got to remember, when the US Constitution when our founding fathers were creating it, they were concerned about the federal government. They didn't want a monarchy, So we don't think about it, but those first 10, those Bill of Rights, initially they were federal. You got to remember, First Amendment, Congress cannot establish a religion. So I always like to remind people, when we talk about due process, equal protection of the law, all of that, 2 places, the 5th Amendment and 14th Amendment. So this was basically saying that Defense of Marriage Act is unconstitutional, basically going back to the 5th Amendment. Now, you got to remember that this particular statute was a federal statute. It was trying to define marriage between a man and a woman on a federal level, not a state level. It would be a few years later where the Supreme Court would come back and say states could not outlaw same-sex marriage. So keep in mind, this is something that's critical, that when it comes to our legal system, we have a federal court system and we have a state court system, okay? But when U.S. Supreme Court, when they hand down a decision, it affects all of us, but depending on the law that they're looking at, this was a federal law. This was not state. This is why it only outlawed the definition, trying to make it between a man and a woman on a federal level. I'm going to go get another case that you need to be familiar with, and it's very strange to us in this modern day world, and that is Mulberry versus Madison. Now, Mulberry versus Madison basically is the United States Supreme Court decision that established judicial review. And for those of you that do not know what judicial review is, or what we mean by that concept, is basically the United States Supreme Court is the highest court of our land, and the US Constitution is the ultimate law of our land. Yes, in 2022, we're all like, it's very strange to us. But you got to remember, when our country was founded, they were still trying to figure things out. So this is that landmark decision that we don't think about in our world, because we know it's just understood that the United States Supreme Court is the highest court of our land, and the US Constitution is the ultimate law of our land. And nothing can go against the US Constitution, not a state constitution, not a federal statute, as we just saw with that Defense of Marriage Act. That's the ultimate law of our land. So I'm going to Shepardize Mulberry versus Madison, but I'm going to look at it more in terms of a citator, a secondary resource. Yes, over here, it gives us a breakdown of all the different jurisdictions that have cited this particular decision. But I'm going to go up to this other citing sources. In this way, if I wanted to see law reviews in law journals that cited Mulberry versus Madison, I can click on my law reviews in law journals. And here I have, a list of those secondary sources that have cited this particular case. But let's say, you know what? I want to look at more recent law reviews in law journals. I can use my timeline, and it's letting me know that the oldest law review in law journal that we have that mentions Mulberry versus Madison is from 1960, but I'm going to just kind of move this on over because I want to get stuff in the last, let's just say the last 22 years. And I'm going to say, okay. So here I can see the more recent law reviews in law journals that mentions Mulberry versus Madison. But I also want to point out this search within results. This will allow me to do a search within these 8,117 documents. So basically, I'm now saying, okay, I've got all of my secondary sources that mentions Mulberry versus Madison, but more importantly, those that mentions Mulberry versus Madison in the last 22 years. Let me see, out of these 8,117, how many of them mentions slavery? I'm going to click on my search. So it's going to look within these 8,117 law reviews in law journals that we know mentions Mulberry versus Madison, but produced in the last 22 years. So now I have all of the law reviews that also mention slavery. So we, at this moment in time, we're using Shepards as a research database, saying, okay, got all my cases that mentions, all those secondary sources, but more importantly, law reviews and law journals that mentions Mulberry versus Madison. I narrowed it down to the last 22 years. And now let me see all of those documents that mentions the word slavery. But I'm going to clear this because if you attended my secondary, the webinar on secondary sources yesterday, I told you that when I search secondary sources, I don't like to do full text keyword searching, which is what I just did. I like to look in the title, because if my search terms are mentioned in the title, I know it's going to be more relevant, more on point. So now what I'm simply doing is I'm saying, okay, look in the titles, and just the titles of these 8,117, using my segment, my field of slavery. So nothing within the titles, but I just kind of wanted you to be aware that you can use Shepards as a research tool. So does this all make sense to everybody? So like I said, Shepards, most important thing, validation tool. However, it is also a research tool because it can help us find other cases dealing with the same legal principle or concept. But the thing you have to understand is that there are three things you're looking for: overturned, overruled, reversed, reversal. And also we got to check in balance. When you're looking at the analysis and it says overruled in part or reversed in part, key thing for you is you got to go read that document to see what legal aspect was overturned, overruled, or reversed, or even, superseded, because what the court is doing at that time is only making a part of that decision bad law. So at this time, yeah, okay, she's just saying if there's, I'm kind of finished talking. Just want to see if there are any questions, concerns, or comments.
Hi, Lynn, this is Brian. I have a question.
Yes, Brian.
How often is Shepards updated?
Shepard is trying to be updated as quickly as possible. Because of nowadays with, a lot of this being done electronically, it is usually updated within a 24 to 48 hours if we can. And that's usually U.S. Supreme Court decisions because they are landmark, but usually within a matter of a week or two.
All right, great, thank you.
Something of significance, meaning the analysis. Now, in terms of another case, just citing it, that's done fairly quickly. That's just a matter of, that's more behind the scenes. But when you're getting to the analysis, that's basically what somebody's got to read it, make the determination. That takes a little bit more time, but usually when it comes, depending on the court, usually Supreme Court, yeah, we're getting that up to speed ASAP because it's going to have an impact on our country as a whole. Does that make sense, Brian?
Yes, it does. Thanks.
Yeah. So, back in the good old days when we had books, that was always one of those things is that, books are not done as easily as online. We got to print the books had to be shipped out, things like that. But with online, it is much more up to date. Like I said, when especially when it comes to U.S. Supreme Court, if the U.S. Supreme Court hands down a decision, and we know that decision has a major effect on, other U.S. Supreme Court decisions, that's going to be done ASAP because we know the impact is going to have. So, usually you're looking at, other areas, within a week or so, because like I said, that is actually still done where somebody is reading the analysis and trying to make, what does this all really mean in the big scheme of things concept. Anyone else? Well, like I said, this is where legal research gets a little tricky. Like I said, a lot of times, students want to forget about the Shepardizing. You cannot forget about the Shepardize. You must always remember, you find that decision, you like it, you think it's relevant, you Shepardize it. And you Shepardize it regardless of what the lucky, oops, I'm so sorry, I didn't show the lucky charm symbol. Please forgive me, let me just, my apologies. So I'm going to Shepardize this case. Down at the bottom, I'm going to go, my apologies. I just realized I did not. You get to the bottom, you're going to see this nice little box. If you click on it, this will give you a description of, what we mean by the red triangle, the exclamation point in the circle, basically what those different treatments mean, which are very nice. But like I said, just because you see the green diamond and the blue, which are basically neutral analysis, you still Shepardize. That's just one of those things that we just do. Like I said, the analysis, the symbols are nice in terms of letting you know what the analysis is. But from a practical point of view, that's just something we do just to do it, just to cover ourselves. Yes, we're in the business of trying to give you the analysis. This is our bread and butter. But, I always tell people, something happened, and, you can't go back and say, well, the symbol on the case was, a green diamond. The court's going to say, well, did you Shepardize it? And you say, no, you rely. I mean, it's just one of those things. It's basically covering yourselves. Yes, we've never made a mistake, but mistakes happen. That's just life. So I just always say, regardless of what the symbol is, you still should Shepardize. That's always my, one thing I say, just do it just to do it. Just follow that step. Okay. Anything else Julia, in the chat?
No, nothing else in the chat. Thank you for going over those symbols and the whole process. I think it was all really helpful.
Yes, this has been great. I've learned quite a bit myself.
Oh, good. Like I said, this is my favorite one because there's so, you don't think about it in terms of the historical impact, but, it does. It shows you, over time, we've, even though to me, the Clinton administration really wasn't that long ago, it was, and how much has changed, since that administration. So, it just kind of shows you, and also shows you how our government and systems work in conjunction with each other, that check and balance. No, it can never go back to being green. Basically, when the court overturns something, they overturn it. It cannot go back to being green. Basically, what they're saying is that law is bad. Now, don't get me wrong. I guess it could. Let's just take Roe v. Wade. I try not to get, political. That's a hot topic in our country. Now, Roe v. Wade would not go back to being good law. The court would probably hand down a new decision, and that will make that law. But Roe v. Wade, let me say this. If Roe v. Wade, if it gets overturned, would go back, would become bad law. That's what I'm trying. Roe v. Wade is probably not the best decision. Let me think. I'm trying to think of something that is going on right now. Roe v. Wade, if Roe v. Wade, let's just put it like this. If Roe v. Wade gets overturned, and then let's say, 15 years later, the Supreme Court comes back and says, we were wrong with overturning Roe v. Wade. Roe v. Wade itself is still bad law. That new decision that it creates, reestablishing abortion, would be the law. Does that make sense? Let me use this as an example. So it's kind of like it goes back, but it doesn't, because at one point we're saying that's bad law. Roe v. Wade itself would not come back as good law, but whatever new decision. So once it's read, it's pretty much, the only time I can think of is when we talk about the death penalty. And let me try to use that. Yes, the new decision is now the law, right? So that would be the law that, reestablishes. Let me do this. Greg versus Georgia. Hopefully I got them in the right order. Georgia was involved in 2 landmark decisions dealing with the death penalty. So let me just Shepardize. And I think this is the second one. I don't think this is the first one. So my apologies. Okay. I'm trying to think of the first one. So this is the one, I'm just going off the top of my head. Greg versus Georgia is the one that brought back the death penalty. There was one, and so that's, I'm sorry, I can't really think. I'm trying to think of something where we went back and changed our mind on something. It doesn't happen very often. Once our court kind of decides something, we pretty much, go forward with that. Now, we will make exceptions to the rules, like death penalty. At one time, we made it constitutional. At one time, We said it was unconstitutional. Then we brought it back and said it's constitutional. So Gregg versus Georgia is the one that says, yes, it's constitutional, and we've made exceptions to the death penalty, but rarely do we go back and, I mean, I'm just kind of thinking in history, especially landmark Supreme Court decisions. Roe v. Wade is probably the closest one in modern day time that we really, really have revisited and debated. But like you said, if it becomes overturned, overruled, and something comes back a few years later and says, no, we're wrong, that would be the new law that establishes what the law is for our country, for our land. Sorry, I'm kind of rambling, but I was trying to think of something that I can give a good example where we did something and came back, and death penalty is the only one I can think of. And like I said, the law is that Gregg versus Georgia, this is the one that's coming to mind, and I can, where we brought it back and it has pretty much saying, we've made exceptions saying, okay, we don't put anybody on death row younger than the age of majority. And then even if you over the age majority, you got to have the mental capability. So we don't put anybody on death row that is mentally challenged. So we may carve out exceptions, but we all know that death penalty, one can still be sentenced to death row. So sorry, I can't, give an exact, but hopefully that gives you some insight. Let's see. Yeah. So yes, the new decision, correct. All right. Well, I really want to thank you all for coming on a Friday afternoon. I know Fridays can always be kind of, they're catch-22. Oh, you're more than welcome. Thank you for coming. Julia, Brian, anything else? I've looked at the chat. Anything you ask?
I think this has been great. We've enjoyed having you, and we hope to have you back again soon.
Oh yeah,
Yes,
please do. No, thank you all. I truly appreciate the opportunity. So thank you very much.